BC just got hit with a court ruling that it has been trying to avoid for years. A decision that could completely change how every law in this province works, from forestry to mining to real estate development. This wasn't just a legal battle. It forced judges to answer a question that the government hoped would never reach the courtroom. Does the Declaration on the Rights of Indigenous Peoples Act, or DRIPA for short, actually have teeth? And can the courts use it to override provincial law? Last week, the Court of Appeal gave its answer. And that answer doesn't just matter to governments or industry. It matters to every single British Columbian who owns property or plans to buy and develop land in this province. Today I'm going to be breaking down what happened, why it matters, and how it directly connects to the Cowichan tribe land claim that I went over in my last video. Because together, these cases show that the legal landscape in BC is shifting a lot quicker than people realize. If you watch the Cowichan video, you'll remember that the courts acknowledged something enormous, and that up to 95% of BC is still on unceded territory. Meaning, the Crown's underlying title, the foundation of our entire property system, could be legally uncertain. That case was about who actually owns the land. This new ruling picks up where the Cowichan left off, but it comes from a different angle. It asks a whole new question. Even if the Crown believes it owns the land, can it make decisions on the land without meeting the standards set out by DRIPA or UNDRIP? To understand that, we need to introduce two concepts clearly. The first is the United Nations Declaration on the Rights of Indigenous Peoples, or UNDRIP for short, a global human rights standard. The second is BC's Declarations on the Rights of Indigenous Peoples Act, DRIPA, as I mentioned earlier. DRIPA was passed into law by the NDP in 2019. And it was meant to align BC's laws with UNDRIP. But here's a crucial piece of political context. When DRIPA was introduced, NDP Minister Scott Fraser repeatedly assured industry, municipalities, and the public that DRIPA would not create new rights, not give courts new powers, and not have any immediate legal effects. He framed it as symbolic, a framework for future cooperation. But behind the scenes, multiple Indigenous rights lawyers warned the government that this would be misleading. They told the NDP directly multiple times, if you put UNDRIP into legislation, judges will use it. Courts will interpret the laws through it. And DRIPA will have immediate legal consequences. And last week's ruling proved that they were right. Now, let's get to the case itself. To understand the legal battle, we need to know what system was being challenged. And that is British Columbia's free entry mining system. Rooted in 1859 colonial law, allowed any free miner to stake a claim on Crown land and instantly gain rights to the minerals underground. And in 2004, BC put that entire system online. This was called the Mineral Titles Online Registry, or MTO, a fully automated grid map where anyone could click, pay a small fee, and get a mineral claim. This was a digital land rush. No human oversight, no environmental review, and absolutely no consultation with the Indigenous groups whose land was being staked. And the Gitala and Ahadasat First Nation groups were the first ones to challenge that. They argued that the system caused immediate spiritual, cultural, physical, and economic harm. Spiritually, the Ahadasat said that mineral claims threatened sacred crystals. For the Gitala, claims infringed spiritual dens that their own laws forbid disturbing. Economically, every claim created a chattel interest, which is a personal property right in the minerals themselves. That meant the future value of Aboriginal title resources were being diminished the second someone clicked the button. Physically, a mineral claim gave the right to extract up to 1,000 tons of ore per year without any further approval. That meant trenching, drilling, and clearing the land, all before any consultation. So the nations went to court. And in 2023, the BC Supreme Court agreed with them on one major point. The automated system violated Section 35, duty to consult. The judge ruled that the system caused real harms, and that Consultation must happen before granting a claim, not years later. He issued a declaration of breach, but suspended it for 18 months so BC could redesign the whole system. He did not cancel any existing claims because of the de facto doctrine. The de facto doctrine basically means that people shouldn't be punished retroactively for relying on a law they believed was valid. The nations lost the second part of this case, which was about DRIPA. The judge said that UNDRIP was non-binding and DRIPA created no enforceable rights. He also said that the courts couldn't check whether BC laws were consistent with UNDRIP. And that second ruling is what set up the appeal by the nations. And the Court of Appeal saw things differently, very differently. The judges ruled that the trial judge took an unduly narrow approach. They focused on Section 2A of DRIPA and made a historic ruling. DRIPA actually incorporates UNDRIP into British Columbian law. That means UNDRIP isn't symbolic. It's not optional. It's a binding interpretive standard that judges must apply. So what that means is that if a BC law can be read in a way that aligns with UNDRIP or a way that doesn't, the court must choose the UNDRIP consistent interpretation. The court also rejected the government's argument that this was judicial overreach. They said ensuring BC laws comply with the standards that the province adopted is literally part of their job. Then the court applied this new standard to the mining system. And this is where Article 32 of UNDRIP becomes impossible for the province to avoid. Article 32 requires governments to consult and cooperate with Indigenous peoples to obtain free, prior, and informed consent before approving projects that affect their lands and resources. The free entry mining system and automated zero consultation process was the exact opposite of that. So the court ruled that the Mineral Tenure Act, as implemented, was inconsistent with DRIPA and UNDRIP. Existing claims stayed in place, but the entire regime had to be replaced. And by early 2025, BC had already done so. Now that you understand the rulings, this is where we talk about the real estate impact, because they only make sense once the legal foundation is clear. And here's the part that affects property owners, buyers, and developers most directly. The court's ruling means the province must interpret every law that touches land: water licenses, environmental approvals, forestry permits, transportation corridors, land leases, crown land sales, in a way that aligns with UNDRIP. And even if your land is private, almost all development relies on provincial systems around it. For instance, to subdivide land, you may need provincial approvals. To build a large project, you might need environmental assessment or a transportation link over Crown land. All of those actions engage Crown decision-making, which now must respect UNDRIP rights. In areas where no treaty has extinguished title, which again is most of BC, Indigenous title still exists beneath private and Crown lands. So if you're a homeowner or investor in BC, especially outside of treaty zones, these legal shifts mean Indigenous rights are increasingly recognized as part of your property's legal context. Practically, this means project timelines may lengthen, approval pathways may change, and negotiation could also increase. It is a shift from unilateral decision-making to more of a shared governance. And BC property owners could feel the effects over time. Now, let's tie this back to the Cowichan case. Cowichan asked the foundational question: does the Crown actually own the land it claims to own? This mining case asks a different but equally important question. Even if the Crown believes it owns the land, what decisions can it legally make on that land? Cowichan challenges title and DRIPA challenges governance. And here's the part that's subtle but massive. Before this ruling, Indigenous nations had far weaker leverage before title was proven in court. They could argue, they could negotiate, but until title was formally recognized, something that takes decades, the Crown still had the legal upper hand. Now that UNDRIP is incorporated into BC law through DRIPA, that dynamic shifts. When a nation asserts Aboriginal title, even before the court confirms it, the Crown must act in ways that are consistent with UNDRIP, including Article 32's principle of consent. This means that nations that have open land claims now have more practical power earlier in the process. The Crown can no longer say, "We'll consult you after you prove title," because DRIPA requires all BC laws, including land use, resource management, and decision-making systems, to be interpreted in a way that protects Indigenous rights rights before a title declaration. This could be a significant shift in legal leverage. Title cases now influence provincial decisions long before they reach trial. So here's the big takeaway. 2 Indigenous nations used Section 35 and DRIPA to dismantle a 160-year-old mining system, and they won. The NDP promised that DRIPA would not give the courts new power. The court said, actually, it does, and we're using it. For anyone living in BC, this means that the way land decisions are made could change. Timelines could change. Approval processes could change. Indigenous participation could change. And the idea that the Crown can act first and consult later is disappearing, especially in a province where the courts now acknowledge that most of the land may never have belonged to the Crown in the first place. So if you're wondering how any of this might affect your own property, whether you already own or are planning to buy, feel free to book a one-on-one call with me using the Calendly link below, and I'd be happy to go over it with you.